do we do a real quick pivot to the Google case, because it's going to involve a question again to which I don't know the answer.
Sure.
Google people, everyone, Rumble Media, not Rumble Media. What am I saying? Rumble Videos, Rumble the platform where we put all of our content.
Yeah, well, there's a bunch of people watching tonight because we're live streaming on Rumble as well.
If anybody's watching there, let me know how many people are watching, because I don't have two screens up. I'm still only on one screen. So Rumble is suing Google for Sherman Act antitrust violations. I did a Viva on the Ice where I just walked through the lawsuit. It's a lengthy lawsuit. It's an interesting lawsuit. They're basically saying Google is using its monopoly to favor certain search results in Google search as relates to YouTube videos to the detriment of other platforms, Rumble in particular. They have their own test as to how they believe they can prove that once the video is shared by partner, I forget the wording, but basically Google will show search results that do not even go to the original video source when it's on Rumble, and instead favor other search results and even unrelated search results on YouTube. And they invoked Sherman Act antitrust violations, one of which was time, that apparently Google ties in the YouTube app to installation on smartphones, thus stifling competition. Google just presented a motion to dismiss, a partial motion to dismiss. And we're going to get into that question in a second. But bottom line, they are seeking to dismiss on a Rule 12b-6 the tying count, the count 2 for tying, but not the count 1 for favoring YouTube search results. So I mean, that's the bottom line. They fleshed out basically that, why they should dismiss the second count is that Rumble hasn't even alleged the 3 essential elements to a tying claim. So Robert, I mean, what do you think of the essence of their motion to dismiss? Prediction on where it's going to go, because it seems like it's a legit complaint on relates to count 2. And then the question is, why not go for a full motion to dismiss and set one aspect of the claim to proceed to discovery?
The only reason why they're even able to bring a motion to dismiss, in my view, is because of the Twombly line of cases where the U.S. Supreme Court elevated what a 12b-6 did. Traditionally, under a motion 12b-6 motion to dismiss, you have to presume all of the facts that the plaintiffs alleges are true. And you have to presume all of the inferences that anyone can infer from those facts are also true. And you say, well, you know what? Even if every fact is true and every inference is true, there's still not a claim under the law for some reason. And instead, what Twombly did is the U.S. Supreme Court, because they wanted to protect politicians in this particular case, they said, no, you really need to plausibly plead. All that was going to do was invite courts to superimpose their own judgment and dismiss cases that don't meet the 12b-6 standard, and that's precisely how it's been misused and abused. That's why throughout their motion to dismiss, you see not they failed to plead, but they failed to plausibly plead. That just creates a nightmare set of problems. Down the road, the Supreme Court's going to have to reverse that, reinstate the original rule. But until that happens, you're at the whim of the political biases of the court. So that's where they could lose because of that. They're stuck in the Northern District of California because of Google's related issues. And a lot of those judges there, very big tech friendly. It may be why Steven Crowder hasn't sued yet. They talked about the beginning of February filing suit. We're going in April. No suits filed as far as I know. And I think in part it's because if they research it, they'll realize that's a tough venue to bring a claim in. But particularly if you're suing big tech. There's a reason why big tech engineers all cases to go there, and there'd be too long an episode to get into how that happens, but they're very effective at it. But but as to what some of what they're saying is based on their own version of the facts, and that's my problem with their motion to dismiss. It's their version of the facts is, hey, we don't really tie. Now they claim it isn't plausibly pled, but it was clearly pled, so it's just their interpretation of the pleadings as to whether they suffice. But that's not a pleading issue, that's their interpretation.
And moreover than that, like they're trying to, incorporate by reference the Apache and the GNR licenses, which I'll admit I don't understand. But my impression is they want to bring in these licenses, even though they weren't alleged in the proceedings, by saying that they're necessarily incorporated by reference, knowing that these particular licenses may not show what Rumble needs to show, but might be totally irrelevant. So,
and really. That's a motion for summary judgment. When you add things to a document in a motion, if you add things to your complaint, then they are incorporated into the record as part of the complaint. But when you don't, when you simply incorporate things as part of the defense, then that's a motion for summary judgment, in my view. That's no longer a motion to dismiss. So I think the other thing is they're playing around. They know almost no judge understands the technology. So as far behind as we are and not knowing a lot of the tech, nowhere near. Remember that the parlor judge? I mean, that was it. I mean, Nick Rekieta, who also is on Locals, Rekieta Law, did a great mockery of just what an embarrassment. Like, he basically said people that are senior status probably should never take a big tech case. Probably should be a rule against it.
Well, you know, it's not to be ageist. My dad would be an amazing judge on a tech case because he understands it. But I go back to my only experience of a tech case on a supernumerary, semi-retired family law judge who, after 20 minutes of someone explaining what SEO was and how it worked on Google Rank, said she understood it. And I was like, no, you don't, because I don't even understand it. I've been in the file for months now. So they're like what the commenter was talking about, the chatter, is definitely the case. And as one of the people responded in your YouTube, on the YouTube comment section, they're playing games with what they're doing. And this is what Amazon did. Remember, Amazon pretended, yeah, we host Twitter, but not really host Twitter. And it's totally different and dissimilar. Not really, if you understand what's taking place. And the same with them. They're trying to, the tying accusation is part of all the DOJ and state attorney generals and private class actions they're facing all across the country. So pretending they don't tie is very deceptive. Well, one thing I was going to say, and I should have mentioned it in the video, is it was fleshed out in the Texas antitrust lawsuit. And to say they don't tie, okay, well, how do you explain the fact that the app is pre-installed and cannot be uninstalled? Like, that's another thing which I suspect. I told, I flipped it obviously to Chris Pavlovsky at Rumble. I said, like, go read through the comments because the crowdsourcing of knowledge on the internet is amazing. But, you know, I knew that you can't uninstall these apps, but I don't understand. I know I don't understand it. I'm never going to understand it. I have a blackout when people try to explain it. But let me get to Evgeny's comment, which I had from before, concerning Google. Android OS is BS. The tying thing is Google services. Google was sued in 2016 by EU for antitrust violations because of it, lost in 2018 and was fined $5 billion. So screenshotted that. I'm going to post that on social media. So it
shows. I mean, they think they can gaslight the judge. The confidence that showed is quite, which is frightening more than anything else. Because if you spend any time digging into this, you'll guess very quickly that Google is not being forthcoming. And again, if we applied a proper pleading standard, this would be, hey, you have arguments. That's fine. This is for discovery and summary judgment. This isn't for motions to dismiss.
That's one thing that among the things that I found most shocking when I started doing these videos and comparing US to Canada. The first thing was the difference in freedom of speech between the US and Canada. The second thing was the propensity or the frequency with which motions to dismiss are granted in the United States. I said, whenever I see these things, Sandman was the first one I saw it. I said, there's no way in hell this is going to get dismissed. This is a hearing on the merits, that pleading. And although I was vindicated, on what was it, on reconsideration, I've seen decisions get dismissed or lawsuits get dismissed in the States. Never in a million years, in my humble experience as a practicing attorney in Quebec, would they ever get dismissed here, because these are all invoking arguments on the merits as if to negate the allegations and not to take them for granted in the original suit. But I've seen the way the courts do it. Flynn, Sandman, what else was there? There was some New York Times one. It seems that judges in the United States make substantive determinations on procedural motions to dismiss at a rate which I found shocking, but I've become accustomed to. So, I mean, I guess the one question is, do they succeed? What was the next question I was going to ask? On the motion to dismiss, there's going to be a written response from Rumble. It's not, the judge just doesn't take that for granted.
Yeah, no, there definitely will. And there'll usually be an oral argument on it as well. Okay.
And now, so we'll see where it goes. I mean, it's an outright denial of Rumble's suit, but hopefully, they're going to crowdsource some knowledge here. And if their lawyers don't already know it, I said it's impossible that Google's argument it's convincing, or at least it's compelling, but it's impossible that it's going to call it true, for lack of a better word, because it's not like you're going to have lawyers for Rumble preparing this lawsuit and saying, "Whoops, we forgot to allege the tying elements of a tying claim." To me, it seems implausible that it would have been an oversight. So I
Yes.
take for granted there's more, and that this is just a radical oversimplification and
Yeah,
a
and
distraction.
it's a function. I've complained to courts that when they grant or consider granting these motions to dismiss, they say what you're forcing plaintiffs' lawyers to do is to write 500-page complaints because you're saying, well, you didn't allege this subconstituent component over here. It's like, okay, I can write a 500,000-page complaint that alleges every conceivable fact and inference from every fact to cover every conceivable grounds in anticipation of the case. But then you know what happens? They're like, oh, this is so long. Why is this so long? Because you made it so long, Judge.
No,
So in fact, I had a California Court of Appeals criticize a trial court for doing that. They're like, the trial court later was upset at it, but what they should have done is don't keep granting motions to dismiss on weak grounds that force the plaintiff to continue to file more, longer. I mean, I ended up with like a 393-page complaint in that case because the court demanded it by the nature of fleshing out every conceivable factual legal claim. So it's the courts are creating this nightmare, but they often act as a gatekeeper for protected privileged classes, which might be a good bridge to the Cheryl Atkinson case.
Okay, no, we'll get there actually. But the last question was, so why not make the motion to dismiss on the count one aspect of the claim? And is it when they proceed to discovery? They said in their lawsuit or in their motion to dismiss, they're going to proceed to targeted discovery. In Quebec, you can have an examination, at least under the older rules, and I suspect it's still the same, but you can do a deposition and then seek to dismiss after a deposition or after a discovery. But when they refer to targeted discovery, is that only Google targeted discovery of Rumble, or does Rumble also get to discover Google?
What they mean is that they'll let Rumble look at a few pertinent things, but not everything that Rumble wants to look at. So they'll probably follow this up with a motion for a protective order to limit the scope of discovery. That's their secondary objective. I mean, it's more egregious, or it's less egregious than what happened in the Cheryl Atkinson case, but it's a version of it where they try to basically preclude you from getting the facts to prove your case.